Hello, I'm Abby, and this is Jeannie. Today, we're going to talk about oral arguments for the case NCAA versus Alston.
Right, the court heard oral arguments on March 31st. Let's dive into what the case is about.
To do that, we have to go back almost 40 years to another Supreme Court case called NCAA versus Board of Regents. In this case, colleges sued the NCAA because it restricted the number of football games they could broadcast on national TV networks.
You see, schools could only broadcast a limited number of games with two companies that the NCAA negotiated with.
The Supreme Court ruled that the NCAA was monopolizing football game broadcasts. The justices concluded it violated antitrust law, which is designed to reduce anti-competitive practices.
However, there's a caveat. The court also held that the NCAA also needed the freedom to enforce rules that preserve amateurism. That is, the distinction between college and professional sports. An amateur isn't paid to play professionally.
And since then, courts have been deciding how much freedom the NCAA has to enforce restrictions. This case began in 2014 when several Division I athletes, including former West Virginia running back Sean Alston, challenged the NCAA's restrictions on education-related benefits.
What kinds of education-related benefits, Abby?
Let's see. Things like internships, computer and science equipment, music instruments, and postgraduate scholarships.
All right, let's see what the courts ruled. The district court ruled for the students, so the NCAA filed an appeal. At the next stage, the Ninth Circuit Court of Appeals ruled for the students again, so the NCAA filed an appeal to the Supreme Court.
And in December 2020, the Supreme Court decided to hear the case. First, let's see what the NCAA argued.
Seth Waxman was the NCAA's lawyer. He argued over 80 cases at the Supreme Court. His argument that day was that the NCAA's restrictions are pro-competitive and maintain amateurism, meaning that they keep college sports separated from the pros. He also said that maintaining amateurism should be decided by the NCAA and not by courts. In other words, judges shouldn't micromanage college sports.
Okay. On the other side, Jeffrey Kessler and Acting Solicitor General Elizabeth Prelogar argued for the students. Mr. Kessler is a well-known sports lawyer, and General Prelogar clerked for two Supreme Court justices, Justice Kagan and Justice Ginsburg, and then appellate court judge Merrick Garland. In a way, you could say all three lawyers, Waxman, Kessler, and Prelogar, are legal all-stars.
Mr. Kessler argued that the NCAA's restrictions don't actually make college sports more pro-competitive. Meanwhile, General Prelogar contended that the court should apply the rule of reason rather than the quick look review to the restrictions.
Wait a sec, Jeannie. What are the rule of reason and the quick look review?
The rule of reason requires an in-depth analysis of the economic market to see whether it's anti-competitive. The quick look review is, true to its name, much briefer. It simply requires the NCAA to show that removing the restrictions hurts the market for college sports.
According to Prelogar, why couldn't the court apply the quick look review? It sounds a lot easier.
Prelogar says that it goes against precedent, or how courts ruled in the past. The NCAA has monopoly control over college sports. Restricting benefits that athletes can receive is anti-competitive. It requires a closer analysis.
Now that we have both sides' arguments, let's go on to the justices' questions. Now, there are 9 justices and 3 lawyers, which means that if we went over all the questions, there would be at least 27 questions to go over.
Which is, well, a lot. So we'll be going over the highlights. Each justice will be mentioned at least once.
Okay, let's begin with questions asked the NCAA's lawyer, Mr. Waxman. Justice Thomas asked why the restrictions applied to college athletes don't also apply to coaches of college teams. Why was it that college coach salaries were so high while students didn't receive much compensation?
After Justice Thomas, Justice Alito brought up the potential costs of playing a college sport. While some colleges receive billions of dollars to pay coaches and fund their athletic departments, training leaves students with less time to study, the pressure to avoid harder majors, and low graduation rates. Alito wondered how these costs could be defended in the name of amateurism.
In response, Waxman cited limits to the number of hours athletes train a week. He also claimed that student athletes have higher graduation rates than non-athletes.
Alito, however, remained skeptical. He acknowledged that students in lower revenue sports might not be as affected, but maintained that there is a negative impact on athletes in more popular sports, like powerhouse basketball and football teams.
Justice Sotomayor brought up the fact that while courts prohibited the NCAA from restricting education-related benefits, athletics conferences can still do so. If these benefits truly harm amateurism, why not let conferences impose these restrictions instead?
Justice Kagan offered a different perspective. What if, instead of helping students, what was really happening was that the NCAA was using its market power to fix athletic compensation at low rates to make a profit?
Justice Gorsuch referenced General Prelogar's earlier arguments. The NCAA argued courts should apply the quick look review to its restrictions. However, Gorsuch pointed out that the NCAA has monopoly control over college sports. Shouldn't this be a reason for stricter scrutiny of its rules through a rule of reason analysis? Next, Justice Barrett asked how a ruling against the NCAA would affect Title IX and women's sports.
Abby, I need a refresher. What's Title IX about?
Title IX is a law that prohibits sex-based discrimination in schools or other education programs that receive federal funding from the government.
Got it. And what was Mr. Waxman's response?
He said that if the court got rid of the NCAA's restriction on educational benefits, it would disadvantage lower revenue sports in both men's and women's sports. To cut costs, schools would cut benefits to less popular sports to compensate players in sports that draw more revenue.
Okay, now let's see what questions the justices asked Kessler and Prelogar.
Justice Thomas voiced a key concern in this case. He asked whether lifting NCAA restrictions would lead to, quote, cherry picking, with wealthier schools offering more enticing benefits to draw in the best athletes. With lower income schools at a disadvantage, it could hurt the competitiveness of college sports.
Both Chief Justice Roberts and Justice Breyer wondered how far the court's role extends into businesses, like college sports. The court's ruling in this case could affect a large number of antitrust cases.
Justice Kavanaugh asked Kessler how a ruling in the students' favor would affect future lawsuits. Would lawsuits between students and the NCAA continue as students challenge other restrictions, or would legislation resolve the issue?
This case could have pretty broad implications. If the Supreme Court rules for the NCAA, it'd be harder for students to challenge restrictions in future cases.
But if the court rules for the students, then student athletes could receive educational benefits. It might also open doors to future cases challenging the NCAA's rules, or extend to antitrust cases beyond college sports.
The court will release its decision sometime this year. Meanwhile, that's an oral argument summary of NCAA versus Alston. Hope you enjoyed watching.